Hey guys, it's Jeff. We're just getting started. Sorry, we're trying to use this different computer and we're having some technical issues. Hopefully you can see and hear me. If someone wants to raise their hand, that they can hear my voice and see the screen. Is that working? Anybody? Okay, great. Thanks, Robert. I can see and hear you. Perfect. Okay, so we're up and running. We're going to switch over and use my computer instead of this other one. We're just going to get the PowerPoint. But you are at the right place at the right time. This is our Asset Protection Trust webinar. I'm going to introduce Brett here in just a second. I'm going to pull up his PowerPoint. As soon as I can get it in my emails. Hopefully, if you haven't, remember there's lots of kinds of trusts, and we use trust for a lot of different purposes. We have the Family Living Trust, which is an estate planning tool. And Brett did a webinar 2 weeks ago on the Family Living Trust using this PDF.
Oh no, sorry.
Is there another one? And then we have the Asset Holding Trust, which is a very simple trust that is used specifically to hold title to real estate for privacy purposes. And Cody did a webinar last week on that. And both of those webinars, the videos, are up on our website. In fact, I will show you our website where things are at, where you can find things. There's two places to get access to education on our website. The first is under the Real Estate tab, which you can see right here, and you'll see Education Center, okay? You click on that, and that'll take you to all the free videos and content that we have on real estate investment topics, and it's all done by essentially categories. So if you want to get some information on the Family Living Trust, you can just click the estate planning one. And here's all of our free information on estate planning issues. I think this is probably right here, this Family Living Trust free video. You can click on that, and this will be right here. This is the webinar that Brett did 2 weeks ago on the Family Living Trust. So that's all in our education center. The other place for good content is in our store. These are paid for education, but there's some video education right here. And then we've got some great content on self-direction, on seller financing, wholesaling, asset protection, stuff like that. So that's all in there. So that's a couple places to get access to these videos after the fact. And right now we should be able to get this PowerPoint up and running. Okay, that is working. Okay. Okay, I'm going to introduce Brett Bryce. He is an attorney here at the Borrelio office. He's got over 8 years experience working in family estate planning, asset protection, and trusts. Oh, great. Never fails whenever you're in a hurry that all these software companies want to, no, I don't want any of this. I don't even know. Me and technology, whoever knows me knows that if it's a technology thing, then I'm going to have a lot of problems. It literally hates me, and it always works against me. So, but Brett is heading up our estate and asset protection division of our law firm. So he'll be creating all our family trusts and asset protection trusts. He's a fantastic guy with great experience. And so I'm going to let him take the big boy chair and begin the Asset Protection Trust webinar.
Thanks, Jeff. All right. Well, pleasure to be here with you all today talking about domestic asset protection trusts. I was practicing in Tennessee until just recently. I moved back here to Utah. I have experience with both Utah and Tennessee asset protection trusts. Utah and Tennessee are in the minority of states that actually let you do a trust like this, which is a good thing for those of you who live here in Utah. I believe there's only 3 states west of the Mississippi that allow asset protection trust: Alaska, Nevada, and Utah. One of my friends actually wrote the Utah statute, and he said, Nevada and Alaska are doing these. Why can't Utah do them as well? We want people to keep their assets in state, and so he drafted and got it passed in the legislature, the statute that allows Utah to have somebody who wants to protect their assets be the grantor, be a trustee, so they maintain control, and be a beneficiary, so they also can receive distributions, and they can, it's basically still maintaining all your rights, but you protect it from creditors. So I'm going to go through this presentation. Some of this might be a little complicated. I'm going to try to distill it down for you guys so it makes sense. But basically, it's an irrevocable trust, which means you can't change the trust document. Well, you can make some changes. We're going to talk about that in a minute. But basically, it protects your assets from people who want to take your assets away from you. Protects against future creditors. Can even protect against bankruptcy. Can just make sure that you have the best insurance possible for your personal assets, and the cheapest insurance possible, honestly. It's a one-time fee unless you decide to engage a professional trustee on it, which is something that we can do here at Breglio Law. But it's a very, very powerful tool, and most people have never heard of it or don't have any idea how it works. So asset protection, when we're talking about asset protection, our goal is to protect as much wealth as we can, to make sure that the wealth doesn't have to go through the court system. And we always have to remember that a favorable settlement with any type of potential creditor is a victory. So placing your assets into an asset protection trust is basically one aspect of an asset protection plan, which, if you think about a castle, you have a drawbridge, you have a moat. You're just trying to add as many layers of protection as possible. So I know a lot of you guys have LLC interests. We're going to talk about how you can actually transfer your ownership interest in the LLC to an asset protection trust. So you keep adding layers and layers of protection. And so the goal is to move the settlement number for a potential lawsuit using legitimate techniques. None of this is shady. We're not doing anything dishonest or unethical. We're doing everything that the law allows, and thankfully Utah law does allow this. If you lived in California, you don't have the option of this. You'd have to choose adapt in a different state. So Utah is a great option for Utah residents. There's some talk online. Some people try to say, oh, this doesn't work or whatever. So in the asset protection industry, we call those people negative Nellies. This person who overreacts to one case. And we'll talk about a couple of the cases, why they don't have any negative impact on us here in Utah. But we try to remind these people that favorable settlements are victories and are unpublished. They're not in cases. So there's been thousands of favorable settlements from DAPs, and there haven't even really been any losing cases. We're going to talk about that in a second, but that says that, the slide says, doesn't that mean that the technique works? So DAPs absolutely do work. ADAPT stands for Domestic Asset Protection Trust. So Domestic Asset Protection Trust is a U.S. asset protection trust as opposed to an offshore asset protection trust, in which the trust grantor is a permissible beneficiary. For a long time, people used the Cayman Islands, places like New Zealand, things like that, for offshore asset protection trusts, which are effective, but they're very expensive. They can cost $20,000 to $25,000 to set up, and then the $3,000 to $5,000 per year to maintain. which is very expensive. It's a lot more expensive than setting up a domestic asset protection trust. Here we talk about a price range of between $3,000 to $5,000 to set it up, and if you use yourself or others that you trust as a trustee, you don't have those annual fees. If you use professional trustees, then you have much smaller fees than an offshore asset protection trust. So domestic asset protection trust, we're going to talk about some of the different states here. There's 17 states that allow domestic asset protection trusts. Utah, in my opinion, is the very best out of all these states because you can see here on the slide, there's a 0 days statute of limitations for future creditors. You see down here below Utah, there's a 1.5 to 2 year statute of limitations. Ohio has a 1.5 year. Nevada, which tries to make a lot of noise saying they're so great, has a 2 year statute of limitations for future creditors. So what that means is if you set up an asset protection trust tomorrow and you funded it with the properties that you want to put into it, you transfer title into the trust. In Utah, you're automatically protected. If you went out the next day and you got into a car accident and you killed somebody who's a very high income or net worth person, your property is protected. In these other states, there's some questions about that because they have a 2 year statute of limitations for future creditors. And in Virginia, it's 5 year statute of limitations. All other states are 4 years. So pre-existing creditors, you have to set this up before you get sued or before you actually incur liability where you know you're going to get sued or you have a realistic expectation. You can't transfer property, fraudulent conveyance into this trust because it doesn't work if you do that. So just some of the ground rules for this type of trust is you have to do it soon. You have to plan ahead. You have to be proactive with this type of stuff because we'll go through some of the examples of people who didn't do that and it didn't work. So statutory exception creditors is another issue that we don't have to deal with here in Utah. This is for like a divorcing spouse, alimony, child support. With other states, they have exception creditors for asset protection trusts, pre-existing tort creditors. Utah and Nevada are the only states with no statutory exception creditors. So that's another reason why we like using Utah. One of the things we have to do in Utah is we have to file an affidavit, or it requires an affidavit of solvency for transfer to the domestic asset protection trust, which basically says, I'm not making myself insolvent by doing this, which is just one of the hoops that we have to jump through to get this protection. They want to allow this protection to people who feel like they might need it in the future, but they also don't want people to be making themselves insolvent or committing fraud. So in Utah, we have asset protection trust powers. I'll just go through a few of these here, which are very good trust powers. A grantor can be the investment trustee, which means they can control all the investment options in the trust. They cannot be the distribution trustee, which means they can't be the trustee that makes distribution decisions for themselves as a beneficiary, because that just provides a little bit too much control, which takes away some of the asset protection powers of the trust. But they can have a co-trustee who is the distribution trustee that they trust that is going to give them distributions whenever they want. If that trustee doesn't do that, then they can remove that trustee and replace them with somebody else. And as far as property going into and out of the trust, you can put property in the trust, you can take property out of the trust. If you have a mortgage on a home, you can put the home into the trust. If you need to refinance it, you can take it out of the trust and then you can put it back in the trust. You take it out of the trust to refinance it and then put it back into the trust, because the banks don't like loaning money to trust, but they do have to let you put a property that has a mortgage into a trust. Federal law, the Garn-St. Germain Act, they can't stop you from doing that. They can't do it due on sale. They can't call the due on sale clause due or anything like that. So in Utah, at least one trustee has to be a Utah resident, natural person, a trust company, or an entity like a trust company. The grantor can retain power to fire and hire trustees. And this, when you read the UCA here, that's Utah Code annotated. So this is all part of the statutes of the state of Utah. The grantor can retain veto power and testamentary power of appointment. That's a tax technique that we won't really get into today, but just want to let you know that the grantor has a lot of powers to maintain control of this trust. And it's a grantor trust, so you don't have to file a new tax return. It just all flows to your taxes. So let's just get into some of the, just for some of the naysayers out here, just to disprove them, prove them wrong. Some people say, does this technique actually work? I mean, if you read some of the stuff, as I said before, online, some people try to poo-poo it because they're trying to sell different other avenues, I guess. But a domestic asset protection trust definitely works for a resident of the DAP state, and it's actually the best way to achieve protection of a primary residence. And as I discussed earlier, briefly, LLC ownership interest. And so here's a question: does it work for a resident of a non-DAP state who sets it up under the laws of a DAP state? Very large majority believes it works. And there's actually been 3 cases. We'll talk about the 3rd case here in a second, but this Dahl versus Dahl case is actually a Utah case in Utah County that we'll talk about the details of, and also INRI Huber is a bankruptcy case. So let's talk about Dahl v. Dahl. This is a really interesting case. I read all the details, all the court filings on this. Pretty interesting. This was several years ago. I believe Charles Dahl is a doctor in Utah County. They tried to set up a Nevada domestic asset protection trust, transfer his residence. His wife agreed to transfer the residence. This was a trust just for Charles, and a LLC membership interest holding brokerage assets to the DAP. And then after that, Charles became divorced. The trust assets were protected at the district court level. Charles won on summary judgment. But this was actually disallowed when he went to the Utah Supreme Court, because it's not because the DAP didn't work, it's because the attorney who was drafting the DAP drafted it wrong, and he made it a revocable living trust, which has no asset protection powers. So it's a crazy case, because this guy was basically trying to commit fraud on his wife. He's hired somebody who didn't know what they were doing as far as drafting an asset protection trust. And the Utah Supreme Court obviously wanted his wife to be able to not be defrauded out of all their marital property. But moral of the story on this one was he didn't set it up the right way. He didn't draft it the right way. So it has to be an irrevocable trust. And he had language in there that made it not an irrevocable trust. So this is not an example of a DAP failing. This is an example of him not doing it right. INRI Huber, this was interesting. Donald Huber was a real estate investor. The real estate market was crashing. He had numerous personal guarantees, and so he set up an Alaska domestic asset protection trust, transferred in some cash and a 99% LLC interest holding more than 25 different LLC interests and other assets, thereby leaving himself insolvent. He set it up too late, which is one of the problems, because he was becoming insolvent, and he wanted to save his assets, but he didn't do it proactively. So it was a blatant fraudulent conveyance. The bankruptcy court was able to undo that transfer, and he was not an Alaska resident. So it kind of, there's been a newer case also with another Alaska domestic asset protection trust with some people from Montana who also were in the middle of getting sued, and they decided in the middle of the lawsuit they wanted to create an Alaska domestic asset protection trust, and That didn't work either. So the moral of the story and what the court kind of held in that was that they weren't an Alaska resident. So moral of the story is if you live here in Utah, you need to do a Utah Domestic Asset Protection Trust, not a Nevada Domestic Asset Protection Trust. If you live in Idaho or somewhere like that that doesn't have a Domestic Asset Protection Trust statute, then you should use Utah to protect yourself. But if you live in Utah, you should use the state that you live in for sure. So here's the question: does ADAPT work? If almost all potential creditors have been frustrated to the point where they choose to either settle the dispute or go away altogether, doesn't this mean that almost every DAPT has worked? And we're going to talk here about a way to make a DAPT absolutely foolproof. If this is what you want to do, it's called a hybrid DAPT. We're going to talk about it here briefly. Sorry if this is a little complicated, but basically just want to tell you that any of those issues that those people had in bankruptcy and other those other cases, which in my opinion there's bad facts in each of those cases because people didn't do it right or they didn't set it up early enough. But we're going to talk about a third-party irrevocable trust that works 100%. There's no question about it at all. This is an irrevocable trust in which the grantor is not a beneficiary initially, but the grantor retains the power to fire and hire trustees. And we can use what's called a floating spouse provision, which means that in the trust, we don't list the current spouse, we list whoever the spouse is at the time. So if somebody gets divorced, they get remarried, their new spouse can allow them to still operate the trust agreement. So while we talk about this, just remember that we talked about the Domestic Asset Protection Trust so far, which does work where you can receive distributions. But if you're a little nervous and you want to have extra protection, this is another option here. And in the trust, we would draft what's called a trust protector provision. This is something probably that the attorney that you work with would serve as a trust protector to allow the inclusion of grantor as a future beneficiary. So with this trust, if a grantor loses his assets that are not in the asset protection trust, his spouse can take care of them. We know for a fact that these work to protect assets from creditors of the beneficiaries, no question at all. So here's a question: even if you aren't a beneficiary initially, from a pure asset protection standpoint, would you rather have $10 million net worth? If you're sued and the judgment is for more than $10 million, you're suddenly broke. It's a bad situation to be in. Or if you had $10 million net worth, if you transferred $2 million to an irrevocable trust for your spouse and descendants, now you have $8 million. If you're sued and the judgment is for more than $8 million, technically you're broke, but you can indirectly live off the $2 million in the irrevocable trust. So if you have 10 million net worth and you transfer 2 million to a discretionary trust for spouse and descendants, you have 8 million left. If you got divorced, the 2 million in the discretionary trust is not part of the marital estate. So only the 8 million is part of what would be divvied up in a divorce proceed. So the marital division doesn't include the 2 million, but you can indirectly access the 2 million in the future through your next spouse, through the floating spouse provision, or through your children. So this is what's called a hybrid DAPT. It's a third-party trust that can be turned into a DAPT. Concept applies to incomplete gift or completed gift. We won't get into those distinctions right now. So the grantor doesn't really need to see his name in the trust agreement as a discretionary beneficiary. Assuming a good relationship with a spouse, a trust for a spouse and descendants isn't much different than a DAPT. But you also, as we said before, you give the trust protector, somebody that you really trust, or somebody that is an attorney or a fiduciary that we put provisions into the trust where they have to act in your best interests legally by law. Give the trust protector the power to add the grantor or remove the grantor as a permissible beneficiary. So this actually avoids the 10-year clawback if the grantor goes through bankruptcy. So in this case, the Bentley versus Mortensen, the DAPT assets would have been protected using a hybrid DAPT. And so if the grantor sued, a hybrid DAPT avoids the uncertain outcome that could be possible with a regular DAPT. But like we said before, there has been no case law where that has happened. There's been no regular DAPT that has been broken by people who did it correctly and did it proactively. But this hybrid DAPT is even stacking the odds even more in your favor. You get the cash flow without being a beneficiary. If you assume the grantor sets up the hybrid DAPT for the benefit of the spouse and descendants, there's different ways to access the cash flow. One, you can do a distribution to a spouse who shares it with the grantor. Number two, you can sell investment portfolio to the hybrid DAPT for a promissory note, so the hybrid DAPT can get cash flow to grantor by paying down a promissory note. You sell other assets to hybrid DAPT for a promissory note, or have the trust loan money to the grantor for a promissory note. And after you do all those things, you can, as we said before, like with a regular DAPT, you can ask the trust grantor or the trust protector to add the grantor as a beneficiary. So there's lots of different ways to make sure that no matter what, you're going to get the money that you need to get out of your trust, but it's all protected. So it's there's no case law that has shown that a regular DAPT has ever been broken by people who do it properly. But if you want to guarantee success and you're okay with the scenarios that we just put forth, then you can do a hybrid DAPT as well. So another option is to have trust split into a couple different trusts. We won't really get into the details of this right now either, but basically you do two different trusts where you separate your assets so that you're taking assets from one trust as a beneficiary, but if you got sued, you have another trust that is even more protected. So this is just an example of if there's no current creditor issues, you start taking money out of the trust that has 20% of your assets, and you leave the other 80% in the other trust, which has even more protections. But if you have current creditor issues, you put even less into the trust that you're taking distributions out of. So we can have our cake and eat it too. We have the ability to access the trust assets. We're protected from creditors, not subject to estate taxes, not subject to future lawsuits, not subject to bankruptcy if you do it the right way, which is always a consideration, because if you're taking risks, hopefully you're protecting yourselves, but you want to make sure that all provisions are accounted for. So that's it. I don't think there's any questions. Be happy to talk with anybody who's interested in this. You can call the main number here, or email me, or go from there.
Does anyone have any questions? You can raise your hand. I've got a question while you're maybe thinking of questions. First, don't get muddled down in the kinds of trusts that are out there. What we do is we'll ask you the questions. We'll find out what assets you have, what assets you want in to protect, what kind of income streams you want off of it, and then we'll design what works for you. So you don't have to say, this is what I need. You just pretty much want to know that you want to protect your assets, and we'll get them protected in a way that works best for you. But one question I have is, will clients need both a family living trust as well as an asset protection trust?
Yeah, that's what I would recommend, is that we do an asset protection trust, make it payable to the family living trust, so that the family living trust, which will hold other assets that you wouldn't necessarily want to put into an asset protection trust, would determine how everything is distributed at death, and that way you only have to have one trustee of the family living trust upon death. At that point, the asset protection trust would pay out to the family living trust, which also after death has has asset protection provisions if the way that we draft it for the beneficiaries.
Okay. Got a question from hi Diane. Just good to see you on the webinar. Diane's asking, please explain the difference between the asset holding trust and the asset protection trust. The asset holding trust is again a very simple, like 6-7 page document that is only designed to hold title to property and for privacy purposes, so that your name or your LLC's name is not on title, which is public record. And honestly, asset holding trust is a few $100, and clients usually buy a form from us, and they can hold as many properties as they want and create as many of these asset holding trusts as they want. It's a way, again, it's a way to provide some privacy in how you hold your assets. There is zero protection in the asset holding trust. And that's kind of why we named them the way we named them. The asset holding trust is designed to hold title for privacy purposes, but it doesn't provide any protection. So typically the beneficiary of this asset holding trust is your LLC. So the asset holding trust works in conjunction with your LLC. Then the asset protection trust is an additional layer of extremely strong protection above the LLC, because the asset protection trust would then own your LLC, and your LLC then owns the asset holding trust, if that makes sense. So the asset holding trust is for people who want privacy, especially those that have a lot of real estate holdings. The asset protection trust is for anybody wanting to protect any kind of asset, from LLCs to real estate to cash accounts to brokerage accounts, anything else that we can stick in there. So that's the difference. Did that answer your question, Diane? Does the asset protection trust require a tax return?
No, it's a grantor trust.
Okay.
Can we? Diane's asking, can we use it on a California property? Yes, you can. It doesn't provide as much protection for a California property as it would for a Utah property, but I definitely think you should still put a California property into Utah Asset Protection Trust, because it adds an extra layer of protection, adds an extra layer of hassle for somebody who's trying to attack your property in California. But because California does not have asset protection statute, if somebody did go through all the hassle of trying to undo your property transfer from California, it does not provide as much protection as it would for a Utah property. But I would still suggest doing it.
Yeah, the typical way we suggest for clients with out-of-state properties is to own the out-of-state properties by title in an asset holding trust, because trusts aren't registered with the state, so you don't have to worry about registering LLCs in a bunch of different states. So the asset holding trust is used to hold title to the out-of-state properties. The asset holding trust is owned by your LLC, which provides you good protection. And then for those clients wanting the additional layer, then we add on the asset protection trust.
Yeah.
So typically in an irrevocable trust, you can't make changes and you can't pull assets out. So that's sort of the historical definition of an irrevocable trust. 10, 15 years down the road, if I put all my assets in this asset protection trust, and I decide just to liquidate all my assets and buy my own island in the Caribbean and live my rest of my days there, can I do that?
Yeah, absolutely. You can do that in the asset protection trust, or you can take your properties out and liquidate them. Either way, if it's an offshore island, you might not need domestic asset protection. But
I'll be my own government.
Yeah, you can do your own offshore trusts from your island. But yeah, you can take property out. You can distribute it back to yourself. You can you can leave it in there and be the investment trustee and buy and sell and change assets and do whatever you want to do within the trust yourself. You have all the power.
Okay. Anybody else with a question? You can type it in, or if you raise your hand, I can see that. We can turn on your mic. Cody is also with us here. Cody, do you have any questions or questions you think clients may be asking? Some of the questions I've gotten are, at what level of assets, should I start considering the asset protection trust? I think you could set it up at any time, to be totally honest. It's kind of like a family living trust. People ask me, hey, I'm single, I'm not married, I don't have a lot of assets yet. Do I really need a family living trust? And the answer is yes, you do. Because it's kind of like going to the dentist. You hate doing it, it costs money, it's painful, but you kind of got to just get it done. And as soon as it's done, you're kind of done. And that's kind of true with the family living trust and the asset protection trust, is once it's done, it's done. And it's good, it's good forever. And, you can start as you build assets, you just start sticking them in. And, but if you already have assets, that's great. So we recommend it really at any time. We don't like to put a number on what value of assets. It's really probably a cost analysis for most clients. There's still definitely need for your LLCs, because there's kind of your first line business entities that actually run the rentals and things of that nature. Family trust is very necessary, because it defines how you want your assets allocated upon death, and has a lot of other documents attached to it, like powers of attorney, the healthcare directive / living will, the pull the plug document. So it's got a lot of other functions. But any client who is really intent on protecting their assets, we really encourage the asset protection trust. Anything?
No, I think.
Could you? I'll just say one of the questions is we had talked about the interplay between acting as a manager of the LLC and then having the asset protection trust being the member, and the kind of flexibility that gives a client thinking, hey, how do they still manage the day-to-day operations of the business, but if it's in a trust, how do those two work together?
Yeah, so if you're the manager and the member of an LLC, you would want to protect that membership interest. You'd want to move that membership interest into the asset protection trust. You can still remain the manager of the LLC, so you manage all the day-to-day operations, and you're also the investment trustee of the asset protection trust. So you have all investment managerial control, and you just can't be solely responsible for distributions to yourself. That's one of the caveats, but that's why you have a co-trustee that you trust, that is going to give you distributions when you want. And if for any reason they don't, you remove them as trustee and make somebody else trustee. So
yeah, that trustee is the big sort of kicker with the asset protection trust. You're probably very familiar with running your own LLC and making all the decisions. And if you want to sell a property, you just sell it, you take your cash. And you're probably, and with a family living trust, again, you're also the trustee of it. You can do whatever you want with it at any time, and there's no issues or rules. The asset protection trust, though, to get that extra protection, there are rules about taking assets out and taking distributions out and cashing things out. And you can't do it yourself, because if you treat that asset protection trust like your own little piggy bank, then you're not really treating it as an asset protection trust. You're just treating it as a piggy bank. So that's why that trustee that is the true decision maker is important. And it can be anybody, correct? But typically, most clients who set up an asset protection trust will hire a professional trustee who is familiar with the rules, distribution rules of an asset protection trust. And there are plenty of professional trustees out there. Our office is one of them, and we can act as that trustee for you and help you keep this asset protection trust in compliance and keep its protective nature.
Absolutely.
Okay. Well, no other questions. Good. Well, then I hope you enjoyed the webinar. Sorry for starting a little bit late. This webinar will be, it says recording. Good, it is recording. I forgot to push, make sure I didn't remember to push play. So it did get recorded and it will be available up on the website in probably 24 or 48 hours. If you have additional questions, you can email me, Brett, or Cody, or call the office and set up a meeting with Brett. If you have, to have further questions or want to actually start discussing how set up this asset protection trust. Okay, so thanks guys for joining. We're going to sign off now. Please let us know if you have any questions, and thanks for attending.